let's get going, everyone. We've got a lot to cover. Good afternoon. My name's Ed Davis. I'm with Sequor Law in Miami. I have the pleasure of now, I think for the fourth time in a row, along with my cohort and colleague Warren Gluck, who's a partner at Holland & Knight in New York, of co-moderating this full and frank discussion on developments in the law affecting asset recovery. It's kind of like a Christmas present because you only see the title Full and Frank Discussion. You have no idea what's inside the present, what we're bringing you today. We have two consecutive panels. We are chock-a-block with material, and we try to cover the most cutting edge, including something that just happened today, I believe Polly's going to cover, issues that affect our practices. We do encourage an active audience. We want your hands to go up if you have a question, but we do not want speeches. If you want to make a speech, then you'll have to get your own panel. We're looking for questions so that we can answer those questions and add value. It is important that we move along because we do have a lot to cover. I'm going to take the laboring oar on introducing everybody so that we can get rolling. As I said, my colleague to my immediate right is Warren Gluck from Holland & Knight, who is the lead counsel in the massive platinum cases, an insolvency case that's going on right now. Two down from Warren is Polly Sprenger, a partner at Cat & Muchin. She is an accomplished white-collar lawyer whose office is just 100 feet away from here, it seems, roughly. And I learned something that Polly is originally from West Virginia, which is a little-known fact. But an English solicitor and an accomplished practitioner here. And there might be a theme there. Let's see if we see that as we go along. Two down from Polly is Margot Maclnnis.
I'm sorry, Ed. I'm a barrister, not a solicitor.
Barrister, sorry. I thought she was upsetting. I
We
thought she
care
was upset about the West Virginia
here.
thing, but I got to get that right. I apologize. Then, as I said, Margot is two down from Polly. She is an insolvency practitioner at Grant Thornton. She oversees various high-profile insolvencies and is originally from Halifax, Nova Scotia.
Go Canada.
We have next in between Polly and Margot, Andrew Morganti. He's a principal of Morganti & Co. He specializes in class action lawsuits. He is an American who lives in Canada now and practices, although he has offices in the United States, he practices primarily in Canada. And so we already see a little bit of a pattern with Polly being American, practicing in England, and Andrew being American, practicing in Canada. What could make them want to leave the United States and practice in some other place that's going on now? I don't know. I'll have to think about that. At the far end of the table, Simon Thomas, a partner at Baker & Partners in Jersey. He specializes in asset recovery and trust litigation, and worked with him on several cases over the years. And then last but not least, immediately next to Warren is Howard Sharp, who's a founder of Ardent Chambers and practices in Jersey and London, and handles a wide variety of complex litigation matters, including asset recovery and financial crimes litigation. So with that, I don't know, those of you who've been in this panel before, we move around and try to cover as many different hot topics as we possibly can. I'm going to have Warren introduce the first issue, and so that we can go on. And our first speaker is Margot.
Sure. Welcome, everybody. And I echo what Ed said. It's just an honor to be here. This topic is particularly appropriate for an offshore conference like this, because what the topic is concerns the circumstances under which a offshore liquidation, whether that liquidation arises from pure insolvency or fraud, can be recognized by the rest of the world. Since 2005, the United States, the rest of the world, has made substantial progress in recognizing offshore liquidations. There's a lot of people who work very hard to realize assets, recover assets. In the last 2-3 years, there has been a push against this. In particular, the UNTITLed Working Committee has made the recommendation that the Center of Main Interest determination be made at the inception of the insolvency case. And what Margot's going to talk about, hello Margot, is a letter with 40 signatories sent to Congress of the United States to the same effect.
Thanks, Warren. So in order to understand the significance of the Chapter 15 issue to the offshore jurisdictions, I thought maybe we'd do a quick trot through the history of where we were and where we are now. So certainly, as Warren said, this has been around since 2005. I know for many of us, we were there when Bear Stearns made its application to the courts for its Chapter 15 recognition and was denied. That caused a lot of concern among the offshore jurisdictions and the insolvency practitioners as to whether Chapter 15 was ever going to be able to be used. Fast forward 2 or 3 years, I was a liquidator on Sphinx Group of companies. We made our Chapter 15 application, and the court found that we couldn't be considered a foreign main proceeding, and in relation to the center of main interest, they looked at the activities of, where was the mind and management of the fund, where was it registered, what activities was it undertaking, and the court ruled in that case that we were a foreign non-main, so that you do get some of the same powers. And if you're considered a foreign main proceeding, you can get the stay of proceedings. You can get your foot on the assets that are in the United States, and you have powers of discovery against third parties and powers of enforcement on behalf of the debtor or against third parties. If you're non-main, none of those things are automatic. You have to apply to the court. So it's sort of like being 16 and having to ask dad for the car every weekend. You're not necessarily sure you're going to get what you want, and it's a bit of an effort to go through it. But following Sphinx, we saw the Fairfield Sentry case, and that was just the nirvana moment for IPs in Chapter 15. The court gave Fairfield Sentry foreign main status, and in that ruling, the judge looked at where the period in between the winding up petition and the date that the Chapter 15 application had been filed, and considered that a number of the activities had shifted, and as at the date of the Chapter 15 filing, that the center of main interest was in the BVI, and that it warranted that recognition. So since the Fairfield Sentry case, IPs have been enjoying a fairly easy access and road to Chapter 15. I think you'll even see that evidenced in the Ocean Rig case, where they managed to move their center of main interest prior to the restructuring. So they shifted all of their activities, established their headquarter activities and board of directors in the Cayman Islands, and then when they filed for the provisional liquidation and subsequently for the Chapter 15, they were granted foreign main status as well, and then were able to, that was a $3.7 billion restructuring, and they were able to get recognition for their scheme in the United States, which was important because the $3.7 billion of debt was New York law governed. So that went off and is touted now as one of the most successful restructurings and a good example of the use of Chapter 15. And I know Warren will talk later about Platinum Partners, but that I was liquidator on the International Fund and the Intermediate Fund, and the Chapter 15 applications there were very smooth and afforded the liquidators some great benefits and access to discovery. We were able to subpoena former service providers for their records, and I know there's an issue, I think Warren's going to touch on that later, but certainly the Chapter 15 applications have been going smoothly. Now, as Warren mentioned, the NCB are looking to bring about more unifying changes within Chapter 15 to have it model more closely the model law. And the particular change they want to make is to shift the consideration of the timing of the application from currently at the time you make the Chapter 15 application to the date of winding up, and that's a fundamental change and regression back to where we were in the days of Bear Stearns. So whether or not, I know there are a number of service providers, and certainly in the offshore jurisdictions, our restructuring and insolvency associations in BVI and Cayman and elsewhere are looking to put forward our views on this proposed change, and I guess we can fingers crossed that they won't actually go through with it, but it does pose some serious questions for insolvency practitioners in terms of what are the options going to be, where you need access to the U.S. courts, and hopefully they don't repeal Fairfield Sentry legislatively.
What do we think is motivating this change? Is it because of a legitimate concern about the manipulation of Comey, or is it something more dark and nefarious? And let's hope it's the latter, because that's more controversial.
I'd like to think it's not dark and nefarious. It could just be an insolvency, technical, Puritan attitude amongst some of the judiciary of moving it closer to the model law. And I think there's some, maybe, they might be slightly out of step, because as I understand it, the model law has moved on as well. I mean, the intentions around the model law is to afford the access to courts and to streamline and make all of this more efficient where it's appropriate to do so. And certainly that was in the judgment of Fairfield Sentry. You obviously don't want to grant it where the Comey's being shifted in bad faith, but where there are legitimate, real issues going on, and that has resulted in a shift of Comey, that you shouldn't be denied access to the U.S. courts. So,
Anybody else want to speak to that, Warren?
I would just say that it would make the proposal, Margot's right, it may be well-intentioned, it may be predicated on economic interests, but the proposal would cause a lot of practical problems, I think. Right now, there's, at a minimum, there's some clarity. At a minimum, when there is a serious situation brewing, there is the ability to formulate a plan. If this were to be enacted, you would certainly have situations where there would be parallel, simultaneous office holders asserting rights, remedies, and perhaps even litigating against one another. If you think about the cases that led to this, you've got Refco, which was Sphinx, which, I mean, Bear Stearns, I think, was a very special example, but Refco and Sphinx were serious cases. And there was this element of two competing proceedings in Sphinx that in fact led to real issues. By the time you get to the Madoff case, you put that behind you. And I think that the results and the outcome were better. I can tell you, by the time you get to Platinum, where there's no question, at least when we filed, there was no question as to whether there was going to be a center of main interest test. I mean, we didn't even have an objection, a real objection anyway, from other than from those with specific interests. It would have been a big problem. I mean, you're dealing with big, large cases, billion-dollar cases, and for there to be this type of lack of clarity, I think could be very, very fraught with issues.
When you have any office holder fighting with another office holder, it's extremely expensive, especially if you have well-funded estates. In the Stanford case alone, obviously not exactly the same because it was a fight between liquidator and receiver. Almost $10 million was spent of the creditor's money fighting amongst the two estates. So that is an absolute, and that's probably a conservative estimate, but that's a silly waste of creditor money.
I agree. I would also note that this fight between the office holders, at least on the Platinum case, it was the first known case where the SEC actually expressly carved out the Cayman liquidation from the scope of its order because of the legitimacy, because of Fairfield, that case. It was just so clear. And there was nothing else to say. And I think, but for that, there would have been waste, to put it mildly.
Yeah. So are we ready to move on?
Yeah.
Polly, can I trouble you for the clicker right there?
Is that it?
Yeah, that's it. This kind of like something from Star Trek. So our next topic we're going to deal with is a ruling from the bankruptcy court in Florida that deals with the issue of privilege, which I'm going to present to you. It's a case my firm worked on, and several people in the room actually had a role in this case. It's referred to as the International Oil Trading Company case. It was one piece of a vast group of cases that all emanated out of an attempt to collect a judgment against Harry Sargent III in Florida. And Harry Sargent was unwilling to pay a judgment owed to a Jordanian businessman named Mohammed Al-Saleh, and there was various pieces of litigation, of which the last and the one that ultimately tipped the scales was an involuntary bankruptcy brought against a company owned by Mr. Sargent, and that really ultimately led to the resolution of the case. So as I've said in this conference before, and that's why we talk about it so much, insolvency really, and many times, is the nuclear weapon of, and can be the nuclear weapon of asset recovery. But one of the issues that comes up in that case, and the issue that was presented was whether or not the communications between funder, client, and counsel are privileged. So before I go any further, just show of hands, how many of you are working on cases that are funded by outside litigation funder? That's a big change from a couple of years ago when like one hand went up. So this is an issue that we're dealing with regularly now. And once the other side found out about the fact that the case was funded, they did not want to deal with the merits of the case. They wanted to take the case off the merits and have this very expensive sideshow about the issue of whether or not they could get their hands on the communications between counsel, funder, and client. And so there were numerous hearings and ultimately a ruling from Judge Kimball in the Southern District of Florida Bankruptcy Court. He sits in the Palm Beach Division. And Judge Kimball is a former Chancery judge in Delaware, very, very well thought of among the bankruptcy judiciary in the United States. And he wrote really a tour de force opinion, which I recommend to everybody. It's at 548 Bankruptcy Reporter 825, and it's 2016. And I'm going to just cover two quick concepts because we can't go on and on about each one of these cases. First, the court found the issue was, can they look at the funding agreement and can they look at the communications between funder, client, and counsel? The court initially said they can look at the funding agreement because that's a contract, it's not a communication. However, the court allowed the redaction of anything in the funding agreement that dealt with the mental impressions of counsel or the litigation strategy. So that was redacted and that was produced, and that seemed more than fair. The court then went on and conducted a full analysis of the privileges and found first that that the issue of providing communications to the outside funder was a technical waiver of the attorney-client privilege. And the court said, but that's just the beginning of the analysis because there are exceptions to waiver, and we're going to look at the exceptions to waiver and see which ones apply. And you have to remember that federal courts generally look to the state law in the area in which they sit. So if you're in Florida, this court was heavily looking to the Florida case law as opposed to a court in New York or Illinois or other places might look to the law of the state in which they are sitting. So the court went on and analyzed the two primary exceptions, the common interest exception and the agency exception. The common interest exception, the court first said there are two main approaches in the United States. First, the first approach requires the client and third party to have a legal interest as opposed to merely a commercial interest. So that would put every single communication out there. If your sole interest is in the outcome of the case, you're not going to qualify under this approach as a funder. So all of your communications would be arguably viewable by the other side. And just because you put it in your funding agreement that it's confidential and privileged doesn't make it confidential and privileged. That's just that's not going to get you home. So you should put it there anyway in order to evince the intent, but it's not the end of the analysis. The court then, and by the way, there's an Illinois case and a New York case called Cohen v. Cohen, which specifically says that agreements between funders, clients, and counsel and communications are discoverable under this approach, and they've adopted the first approach. The second approach, and the more expansive approach adopted in the Florida state courts, is that the third party and privilege holder are engaged in some type of, quote, common enterprise, and that the legal advice relates to the goal of that enterprise. The court adopted that second approach and found that all of the communications were privileged between the funder, the client, and counsel. So that was an important piece of it. But then he went on and he analyzed the issue of, I think that's still common interest. Oh, sorry, let's go back. So the second issue is whether or not there's an exception to waiver called agency. If you're an agent of the client, then communications with you and the client are not subject to production, and they cannot be viewed by the other side. So typically that meant a translator or a forensic accountant, but it was not extended to litigation funders. And in the Illinois and New York cases, the court specifically found in the first approach that the test that they were approaching is waiver of protection only applies to persons identified as, quote, translators and possibly to forensic accountants because they're helping a client and the attorney interpret information. So it really is an interpreter function, and therefore those communications are not discoverable. The second approach, and the one that ultimately was adopted by Judge Kimball, was that the waiver protection applies to a broader array of professions with whom communications may be necessary for the provision of legal advice, and included the funder in that definition on the basis that the funder has to make legal determinations along the way with regard to how the case progresses, and also with regard to determining if they even want to invest in the case initially. So I think this is a great development. What's great about this case is that, number one, it's after the Illinois case and the Cohen v. Cohen, which are earlier, 2014 and 2015. This is a 2016 case, and it's seemingly, from the people who are writing about this issue, is being adopted and pushed around the United States. Obviously, this is just one court that doesn't have any precedential value by itself, even in the Southern District of Florida. But it is a well-reasoned opinion, and the judge wrote it with the idea that it might be used by other judges. So I'm going to stop there. Anyone on the panel want to add anything to this?
I just saw a litigation funder in the third row. Take a snapshot of your slide.
You can have the slides. You can have the slides. They're available. Anyone in the audience want to mention anything about this issue in other countries other than the United States? And whether it's been litigated or there's been rulings on the issue of privilege in your home jurisdictions? Anyone? Hearing no one interested in speaking, we're going to move on to...
Ed, I have a comment on that. In Canada, recently, this issue's been litigated, in fact, since 2014, and it seems every 6 months there's a new decision on this, and the courts have consistently held that the terms of the agreement between the funder and the litigant are they must be produced and without redactions, in the sense that
the economic terms, right?
Even the amount of funding, whether it's to finance disbursements, but also on the side of adverse cost awards.
That was true here too. The court required all of the economics to be disclosed, but not the portions where there was an analysis of particular pieces of the litigation, where mental impressions of counsel were involved.
So here it was argued, and one that I'm thinking of in particular, that by exposing or disclosing the dollar amounts, that indirectly exposed the mental impressions of the counsel. And that was heavily fought, and ultimately, this particular case, counsel abandoned the third-party funding for that reason.
Interesting. Very interesting. I guess if you budgeted $10 million, you must think that it's a tougher case than if you budget $1 million. So you can infer certain things, but I'm not sure that inference always works.
Right.
You know?
I think it's worth saying that, as I said, that quickly I'm going to disagree on one point, which is just what's the nuclear bomb of asset recovery? I think it's this. It used to be that you could just drain someone or an estate or a person, and that would be the end. The nuclear bomb, I think, is litigation funding. It's leveled the playing field between aggressor and victim. And I'll say good job, because at least in the US, this is new and interesting, but it's a confederacy. And so there is a hodgepodge of law on this. I think Ed has struck a victory for those who are interested in obtaining secrecy in relation to litigation funding. But I think the cautionary message is beware. You may end up in litigation over the communications with a funder, and the states are only analyzing these issues sort of one at a time. And so what you could genuinely wind up with is different outcomes in different states or different courts, which can be scary.
I will say that The person who deserves the credit for this in my office is my partner, Greg Grossman, who argued this. And just to brag a little bit, the judge told someone else subsequent that it was the best oral argument he's ever seen in his career. So kudos to my partner, Greg, not to me. I just get to report on it. So he did all the heavy lifting. So next topic.
Next topic is also on discovery because it is so important in this world of ours. And we'll hand it over to Howard, who's going to discuss other circumstances in which information that a party may not want to be handing over or stating is at issue in the context of self-incrimination.
Thank you very much. Good afternoon, ladies and gentlemen. There's a trust company in Jersey, and one of its clients is a Norwegian businessman, and the trust company provide a series of complex trust and company structures for that Norwegian resident, who of course owes obligations to pay tax in Norway. And it's fair to say, in briefest summary, that the Norwegian authorities over recent years have taken a great deal of interest in the activities of this particular individual. And that interest has manifested in the Jersey Trust Company being served with compulsory notices. That is to say, notices requiring the disclosure of its pre-existing documents that relate to its relationship with this individual and the trust and company structures they have been providing to him. The trust company sought assurances that whatever their client had or had not done vis-à-vis his tax obligations or indeed anything else, that the trust company and its company directors and officials would not be subject to any criminal investigation or prosecution either in Jersey or Norway. The undertakings sought from the public authorities in both Jersey and Norway were not given. In other words, the trust company was given no such comfort. And indeed, by 2013, there had been a judgment delivered in Norwegian proceedings which was not overly flattering in terms of the trust company's behaviour. So in response to the statutory notices that had been served in Jersey on the trust company, both pursuant to the Tax Information Exchange Agreement legislation and other legislation, the trust company said it wasn't handing over any documents at all, and it wished to invoke the privilege against self-incrimination, rely on that privilege, and thereby not comply with what would otherwise be a lawful demand for these documents, which of course would be of key importance to any such investigation. Litigation on this issue of privilege started in 2014, started 2015. And although the trust company's claims to privilege were rejected by both the Royal Court at first instance and then the Jersey Court of Appeal, matters continued to the extent that last week on Wednesday and Thursday, a specially enlarged panel of the Privy Council sat to determine the issue of privilege. In particular, they sat as an enlarged panel because they were considering the extent to which Article 6 of Human Rights Law, which implicitly provides the right to this privilege, whether it extended beyond mere testimonial dispositions as had been understood following the case of Saunders, and whether in fact it extended beyond testimony and went as far as covering real evidence and indeed, for the relevance of our case, pre-existing documents. And the court, after 2 days last week, reserved its judgment. So we'll have to wait and see what they say, but it may very well be that a number of English Court of Appeal decisions, although that they may have arrived at the right result, it may be that their lordships in the Privy Council will correct the reasoning and logic by which those results should be achieved. And one may see, and I don't put it any higher than that because the judgment is reserved, but one may see an extension of the ambit of Article 6 privilege, and that may have wider consequences beyond the facts of the case going forward for privilege in this area, and it's likely that they will define Article 6, having wrestled with some challenging jurisprudence from the European Court in terms of precisely what it is the European Court's been trying to say for the last 20 years. But It's likely to be a definitive judgment, and it's likely to be very helpful in terms of who can claim privilege and when.
This issue of the privilege against self-incrimination comes up in pretty much every asset recovery case, so it is a hot topic. Anyone want to add anything to that? When do you think we'll get a ruling from the Privy Council on this?
Well, who knows?
In time for Miami, you think? We'll have it before the next conference?
Yeah, definitely.
Okay.
It's just a question of Lord Sumption and Lord Hodge are clearly going to write a substantial judgment, and the issue is how long that will take them because they're busy people. But I would have thought by April there's a decent chance.
Super. Questions, comments? Anyone?
No, and I think it dovetails nicely with one of our next issues from Andrew of Morganti. And then the question is, this is all related. How do criminal investigations, asset recovery, and civil proceedings interact? I think Andrew's going to give us a little bit of a slice as to how parties can be forced sometimes to give evidence in civil proceedings that may be used against them in criminal proceedings.
Yes. We started this off, why did I go up to Canada? And the truth is, it's because the law is developing so quickly. I think over the years, Canada has seen so many large-scale frauds that it's my impression that about mid-90s, there's a big change across all the provinces. And again, Canada's different than United States, where United States, it's the federal government and federal cases that really move these files. In Canada, it's provincial. Each province has its own personality. But it was during the mid-90s, after a few very large-scale frauds, that laws were created, common law was created into statutes. And from that, the law has been continuously developing. And more than anything, I hope the walkaway today is that the Canadian courts, in particular Ontario and British Columbia, the judges really take an equitable approach towards what is the underlying piece of litigation. So, and allowing discovery, allowing creditors, whether domestic or foreign, to trace these assets. And I'd like to highlight a few cases that really are a stark difference to what would have happened even a decade ago. So we ask self-incrimination, what formats would that be? Both in criminal, obviously, but in the context also of civil. You can imagine situations where a party receives an order to produce documents or sit for examination, and they have concerns that it may expose themselves to not only potential criminal exposure, but also possibly being dragged into another piece of litigation. So two cases I'd like to highlight from this past year, and I understand that appeals are going on, but in one in particular, there was a debtor accused of engaging in a very large Ponzi in Japan, who's been incarcerated in Japan and has been foregoing the repayment of about $480 million. It was learned through a Norwich order that this gentleman had, criminal, had assets with RBC in Vancouver, Royal Bank of Canada. And through this Norwich order, RBC produced materials which was followed on with a request for an examination for this person's wealth manager. The wealth manager, RBC, disputed the ability for this examination, then lost, and the trustee who was bringing the claim on behalf of the Japanese creditors went the extra step, and this is what I'm saying would not have happened 10 years ago, asked for leave from the court to allow to use any evidence obtained through the examination of this party from Royal Bank of Canada, to use this information in any subsequent litigation, not only in British Columbia to enforce the judgment, but also litigation in any other country it saw fit on or for the trustee. So again, here's an example where normally under Canadian provincial law, you cannot use evidence in one file for another file. Here, the court took the extra step and expressly wrote in its decision that any evidence taken from RBC can be used in any litigation, not only in Canada, but around the world. Another example that follows this trend involved a dispute over an estate where the estate was being settled in the state of Pennsylvania, United States, and through the process of a Norwich order to the bank, the estate learned that the deceased also had accounts with CIBC, another Canadian bank. And through that process, learned that the deceased's executive assistant, became a fiduciary and had signing authority over the accounts. Well, one, that triggered a problem for this individual because she never reported to the U.S. tax authorities on an FBAR that she had signing authorities on a foreign checking account. Two, through this process, learned that she diverted several $100,000 of funds.
Maybe that's why she didn't file the FBAR.
Maybe. But it's, so the point here is, again, what's different is it came up here and filed an application for the one for Morava injunction. Then a subsequent Norwich application for a Norwich order was applied. And here again, the bank provided evidence, and it was that evidence that forced this person to get dragged into civil litigation then.
Yeah.
So again, 10 years ago, I don't think this would have happened.
I have a question. There is a substantial departure between the American legal system and the Commonwealth system, I'll call it, for the sake of a better description, in which you have this implied undertaking where information obtained in a proceeding can only be used in that proceeding. And we do not have that. So number one, it is a huge trap for an American who doesn't know that when they get documents and start using them willy-nilly, and I've seen it, it's pretty ugly when it happens because you cannot put that toothpaste back in the tube once it's out. Very difficult. But what is the policy reason? Did the court, and I know that this may go beyond this panel, but I've never heard a description of what the policy reason is why information obtained in one proceeding has to stay in that silo of that proceeding and cannot be used in others. Why is there such a divergence between our two systems? And I know I'm hitting you with this sort of cold, but and this is to anybody. Why do we have this? Why do you have this?
Well, I've questioned the same rule, but it was for the protection of, and again, this is the past 10 years, max 20 years, the trend, I think, historically was a closed system to protect, don't put light on something. And now I'm seeing this trend where, you know, in my first example with the Resolution Collection Corp case with the Japanese fraudster, there the court expressly wrote in its decision, you can use this. There is no deemed undertaking here. In addition, we're also seeing that in other types of cases where a letter derogatory arising from U.S. litigation, civil litigation, to an individual in Canada to give evidence, sit for a deposition, or
Right.
what we'd call for an examination. And that individual seeks to quash this motion on the basis of, if I engage in this, I'm going to potentially incriminate myself, either because I'm aware of ongoing criminal investigations in the United States or Canada, or it could arise. And consistently now, for the past 20 years, and you can think of every variation of the facts, but consistently the courts have said, no, you have to give evidence. There's no right against self-incrimination the same way that you do in the United States.
No, it's another departure between.
Yeah, you have to give the evidence, but it can't be used against you in the future unless it's for impeachment purposes only, which at that point, from my perspective, the cat's already out of the bag.
That makes sense. To me, that's a limited form of immunity that you're giving, so you can get the testimony you need. But I'm just wondering why the immunity, and we can park this and come back to it, or if anyone wants to cover it, why do you have this implied undertaking generally? It's not just in a Fifth Amendment setting or in a self-incrimination setting, it's generally.
Right.
And so what is the policy reason driving that? Or is it just, I kind of think we're kindred spirits on this. We never talked about this before, that it really is it's a system designed to prevent the spread of information, isn't it?
Prohibitions on collateral use are designed to encourage the free flow of information in the disclosure process. So if it was that you could obtain information through disclosure or through one of these disclosure applications, that would then be in the possession of the party who had obtained it, and they could do whatever they wanted with it, then that would encourage more people to fight back against disclosure.
So it would chill disclosure.
Exactly, because there would be more challenges to it. So the public policy position is there is no collateral use permitted. It's only permitted for the proceedings for which it was obtained, and therefore there is less reason to argue that by complying with a disclosure obligation, you are creating some ancillary criminal or civil liability. That's the reasoning behind it.
Yeah, I'm not sure I buy it, but I hear you loud and clear, and it's logical anyway. I'm not sure, though, that it's ultimately because we have
I
free
didn't make
flow.
the rules.
I know you
just
didn't follow
followed them.
So anyone else want to speak to that?
I was just going to add that one of the underlying public policies of this implied undertaking is, of course, that if, for example, you're a defendant in a civil action and you're brought to court when you didn't want to be there, you may be being required to hand over evidence that doesn't give rise to any liability on your part, but is nonetheless confidential or has commercially sensitive information in it. And whilst it's appropriate, of course, that the court in which the litigation is being conducted has all the relevant evidence before it so it can reach the right decision, one might say it would be fair to the parties that any intrusion on legitimate confidentiality of documents shouldn't go any further than is absolutely necessary in order to do justice between the parties. And that is undoubtedly one of the underlying public policy reasons
Makes sense.
for the undertaking.
I assume that can be covered with a confidentiality agreement, but that makes sense to me. So question, comment?
Yeah.
John?
I think the policy that applies on the right line. If you allow disclosure in one case to be used in other cases, then in those jurisdictions that don't believe in discovery, you are calling for a multiplicity of lawsuits where you can get the information you would otherwise ask for in the United States through discovery. You have one lawsuit here, one lawsuit there, nibble a little bit here, nibble a little bit there, and soon you have full
Sure.
discovery. I think that is also part of the thinking.
Right behind?
I'm American, don't have any frame of reference with foreign jurisdictions, but couldn't you just insulate yourself from criminal prosecution? In a civil case, you just vomit all of the incriminating evidence and, okay, I've given it all up, now I can't be prosecuted.
The collateral,
What type of evidence do you have to stop that? In the United States, we have what's called the Castigar hearing. They're proper, they go ahead and do that and make a determination as to whether the prosecutor, the FBI, can do that independently of that commitment.
I knew the answer so much that I wanted to interrupt you and say it. I'm sorry. The reason, there is a remedy there. Collateral use applies unless there's a countervailing order of the court. So if I, as a prosecutor, want to use that material that you vomited all over those civil proceedings, I can make an application to the court to use it. And the converse is true. So, for example, a recent case that only just ground to a halt, having started about 10 years ago, the Chengiz matter, There was a whole bunch of witness statements that were given in criminal proceedings and in judicial review proceedings. And there was a follow-on civil case against an accounting firm called Thornton. And
You heard of those guys?
I have heard of them. They have good dinner parties. That case only finally concluded 2 weeks ago in Grant Thornton's favor, I should say. But there were a number of applications that were made by the claimants to obtain all of the previous materials in the criminal proceedings and in the administrative proceedings so that they could be used in the civil proceedings to try and demonstrate and prove liability on the part of the accounting firm.
Is that an exception as opposed to an understanding?
I think your question might be, can you claim privilege and not hand over anything at all? So you
No,
don't, so, because, that's one issue for if you're doing it in civil proceedings, if you have to hand over documents ordinarily, but you're worried about the fact if you do so, you're exposing yourself ultimately to prosecution. One issue for the court in those proceedings is whether or not a claimed privilege could be upheld.
And then the question becomes whether a document could be considered testimony. So in the U.S., we do have this very broad rule that insulates persons from being compelled in a civil setting or a criminal setting from testifying against themselves. What you're describing is a sort of branch of that where can a particular document, i.e. admitting its existence, actually constitute a testimonial act on your part? And the answer is sometimes. And sometimes you don't have to hand it over at all. Yeah, I mean, the mere possession of, acknowledging the existence of a document in certain circumstances and occasion can be acknowledging the commission of a crime. It absolutely flows. Sometimes if you've got it, you're guilty. And I think that's actually a good system because we're going to talk about two circumstances now where those charged with obtaining relief for victims of fraud internationally, particularly liquidators and trustees, can do so. And so we'll turn to Mr. Thomas to discuss whether an issue in Jersey that's come up, which is can a trustee obtain documentation without necessarily obtaining recognition of his office? I think that's the issue, right?
Yes, this is a recent development of the Jersey courts, and arguably it makes life more difficult for foreign office holders to get information that they need to carry out their duties. Put it in this context, Jersey is well used to recognizing foreign office holders. It does it on the basis of comity between courts, but to get that recognition, there is a procedure you have to go through, and it's not cumbersome, but it requires drafting of legal documents, the commencing of proceedings. But before a foreign office holder decides whether they want to act in another jurisdiction, they may want to obtain information to find out if it's worth doing that, particularly so in the offshore context where funds may have been placed in financial institutions there. So there's a recent case that we've been involved in, and it emanated from Ed's firm, which involved a Florida bankruptcy. There was evidence of concealment by the bankrupt through corporate entities and opaque property transactions to frustrate the claims of creditors. And importantly, from the Jersey perspective, there was payments into accounts of companies in Jersey held at a Jersey bank. And so the trustee in bankruptcy, the bankrupt died, and the trustee in bankruptcy appointed in Florida wanted to get information to locate the assets of the bankrupt, and particularly wanted to know what had happened to the transactions that had gone through the Jersey bank. And so the familiar route, will come as no surprise, was to obtain or apply for a Norwich Pharmacal order in Jersey. The bank in possession of information which would enable the trustee to unravel the steps that the bankrupt had taken. Most of you will be well aware of the usual criteria for Norwich Pharmacal orders. There's got to be a good arguable case that the plaintiff is a victim of wrongdoing and reasonable suspicion that the defendant, in this case the bank, is mixed up in that wrongdoing, and then a discretion that it's in the interest of justice to order disclosure to be made. And on that last point, Jersey is accustomed to helping. There are many dicta in the cases that says because Jersey is a financial centre, it will assist when its institutions have been used as instruments of wrongdoing. So, on behalf of the trustee, we go along to the Jersey court and apply for our Norwich Pharmacal order. And out of courtesy, we inform the Viscount, who's an executive officer of the court. We didn't technically have to do so, we didn't think, and said, we're going to do this, we're going to apply for a Norwich Pharmacal order. And the Viscount says, you can't do that. You've got to be recognised before you do that. And we said, well, no, we don't agree, because when we're applying for Norwich Pharmacal relief, what we're doing is acting on the basis that you've got an institution in your jurisdiction that's been mixed up in the wrongdoing, and we're coming as someone who's lost as a result or needs information, and we want that information from you. And we don't want to have to go through the cumbersome process of getting recognised. Well, the Viscount, having set that particular hare running, found its arguments supported by the court and the main judge in Jersey. The court said, no, there has to be a recognition application. How do we know if you come as a trustee that you've successfully rebutted the presumption that the bankrupt acts in the bankrupt's interest in this property or in this action has been displaced? We want to know that the court that has appointed you approves of what you're doing. And they also said, because you have to, when you get a Norwich Pharmacal order, give undertakings, not least to pay the cost of complying with it. How do we know you're going to be good for your undertakings if we haven't got a way that we can control you, including going back to the foreign court and in the event of any default? So what it means is that what should be a relatively accessible procedure, one that can be accomplished quickly, sometimes without notice, has been rendered far more cumbersome by an offshore centre which, on the face of it, prides itself in giving relief and providing information when that information is necessary to unravel the activities of fraudsters. And it gives rise to the issue of what happens if you've got urgent applications. Do you have to go through the procedure of applying for recognition? Do you want to go down that route when you don't know, in fact, if the information is going to be there or going to be any advantage to you? And it seems to me that what this judgment has done is to put the foreign office holder at a disadvantage in respect as compared with any other applicant for a Norwich Pharmacal order. And there shouldn't be, it seems to me, any reason why there's a difference and why the foreign office holder shouldn't come, as any applicant can, and say, you've got this problem in your jurisdiction, we want equitable relief to get the information. So I think that's a couple of steps back for asset recovery.
We have a similar issue in the United States. Did you want to cover that, Warren, just real quick? I mean, it
Sure.
deals with 1780, whether an office holder can come without recognition and seek discovery under 1782.
The answer is muddled.
It is muddled, yeah.
There isn't an answer now. There are a collection of judges who believe that obtaining recognition is a requisite. There are a collection of judges who believe that it's not, and that in fact, if you're just seeking information in the United States, the 1782 process is the process to use. Same sorts of calculus. If you're coming in as a liquidator, you're coming in as a trustee, how do we recognize that status without recognizing the appointment? Simple answer from the Southern District of New York until recently has been, well, Chapter 15 is easy. If they were to implement this rule that Margot was talking about, then suddenly it would become more difficult. It's one that it's a question that we answer a lot because understandably, you don't want to spend money as an office holder if you don't know the information is there. And I think, at least in the U.S., it's about $20,000 more expensive to get Chapter 15 recognition first, and that can be real money if you're talking about a limited estate. The topic I'm going to cover now.
Can I just one thing on that? 28 U.S.C. 1782 says any, quote, interested person, close quote. So to me, I think it should come out that you don't need to get recognition.
Me too.
But we'll see how it ultimately works out once it works its way up to the Supremes at some point.
I'd like to ask a question as well about the Norwich Pharmacal jurisdiction. Were you there in support of proceedings domestically, or were you looking for this in support of foreign proceedings?
Well, we didn't know until we got the information what the proceedings
So,
were going to be.
so you went in there will be some proceedings, I don't know what or where they are, Schlamoon territory.
Well, the reality of this case was that unless we got this, it was really the last-ditch attempt, as I understand it, to get information. If you didn't get information out of Jersey, then you'd really drawn a blank on the whole case.
Right.
So it could have given rise to actions in any number of jurisdictions, but you don't know until you get the information.
It was a gold mine. Stay tuned.
It's an important distinction between the jurisdiction of 1782 and the jurisdiction of Norwich Pharmacal orders.
Yeah,
1782 is available in support of foreign proceedings.
Correct.
Norwich Pharmacal are available only not in support of foreign proceedings. They must be domestic, unless you're in this nice territory where you can defensively say, I don't know where I'm going to bring proceedings.
Well, it's to vindicate any right that you have. It's that broad, so I think that can include, it doesn't have to be limited to proceedings in Jersey.
John?
On 1782, it's not foreign proceedings. It's foreign proceedings or prospective.
yeah, reasonably contemplated is the phrase,
So
yeah.
if you think that if you get something, you will be able to bring or defend a foreign lawsuit, you can bring your application, I believe, in the Southern District without being recognized.
Yeah, certainly. Well, you mean the Southern District of Florida, right?
Southern District of New York.
Southern District of New York, and you
Just
can
checking.
do it arguably prospectively in support of a potential liquidation, which will just turn you out into a circle. And that is the move, is that if you know you're going to need this information, if a creditor knows they're going to they're going to appoint a liquidator in a foreign jurisdiction, you can just speed the process up by saying, well, the foreign proceeding is the prospective liquidation. One of the last ones for this session before we take the break, and then all come back and talk about litigation, where it gets pretty juicy. Oh, yeah, that's right. Is what happens when you have recognition and there is substantial opposition to a discovery request. So we had a situation in Platinum where background is large-scale alleged fraud, billion-dollar case. The Cayman appointed liquidators want information concerning the demise. The last man on the ship, so to speak, before it went under, was the company's auditors, which had been successfully putting out reports for a number of years, and in this particular case, the last year before arrests and liquidation and insolvency. The subpoenas were sent out under the Chapter 15 statute, and the auditor came back with what it thought was a novel argument, and there were 3 oral arguments and 3 published decisions. I think it was actually just pushing together 2 old arguments, but what they said was as follows. Firstly, this U.S. Chapter 15, it's in support of what's going on in Cayman, or it's what's going on in Switzerland, or any jurisdiction that we're talking about today. So shouldn't the discovery that's available be limited to what you would get in that jurisdiction? So you got a U.S. witness here, but if the U.S. witness were to be in the foreign jurisdiction, shouldn't you be limited? The answer was no, not even close. They accepted our language, both courts accepted our language that the U.S. courts are not mere avatars for the foreign court. They do their own thing, and the rights associated with Chapter 15 are substantive and can include rights that simply aren't even available in the foreign proceeding. The other thing they said was this. They didn't want to turn over work papers. The very mental impressions concerning the very purported assets that turned out to be a lot less value. We said, you're the witness, you're the last man on the ship. And they said, well, you're going to sue us. We have an arbitration clause in our contract. That arbitration that was contended provided for limited discovery. Now, I'm not sure if the work papers would not make it into any arbitration. I think nobody accepted the premise, but everyone went along with the argument, and they said, okay, let's assume there is an arbitration clause, and let's assume that that arbitration clause does provide for limited discovery. Does it matter? Does it matter that you're a contractual current counterparty, prospective litigant? There's a Daisy Tech case out of the Southern District of Texas, 20 years ago that suggested the answer was yes. Now we have a roundly resolved answer, which is no. Court decision issued by the bankruptcy court, which we argued, decision issued by the district court sitting in its appellate authority, again, in the affirmative. And then it went up to the Second Circuit. And what's shocking is that this wasn't really a test of sort of legal theory. The second that the Second Circuit denied the stay, they dismissed the appeal and ultimately produced the documents. The moral, I think, of this story is, kind of goes back to the beginning of the session, which is what Margot was saying. There are real cases out there, and the tool of Chapter 15 to assist a liquidator, an office holder, a foreign representative in simply finding out what happened, it's a powerful one. That power was checked in a major way by a major company with major legal representation making serious arguments, or what they thought were, and was roundly rejected. So we have some serious new precedent on this issue, 2018 precedent, all the way through to today. And so it's, I think, another positive development.
Speaking of new tools, Polly's going to finish off this portion speaking about unexplained wealth orders. But in our preparation for this, I asked the question, well, are these available to private prosecutors? And which begs the question, and so I think it's several people in this audience, I'm sure, never heard this phrase, private prosecutors. You are a private prosecutor. I believe you've done private prosecutions and a former prosecutor. Could you spend a couple minutes explaining private prosecutions and their use in asset recovery and then work in the unexplained wealth order? I don't mean to hit you with anything that's way outside of your topic.
You've given me two totally unrelated topics that you want me
But
to
I have
work together in the space of 5 minutes.
total faith you're going to do that.
Yeah, I am, but first I've got to argue back about the Norwich Pharmacol order. A recent case called Ramelos in this jurisdiction, don't know if it's replicated in Jersey, says that there is no availability of Norwich Pharmacol relief if you are intending to bring proceedings in another jurisdiction. Now, that might seem like a fairly esoteric concept, but having been on the sharp end of Ramelos arguments on several unsuccessful and challenged Norwich Pharmacol applications recently, it's kind of foremost of my mind. I think I can knit the really tangential topics that Ed has just assigned me together by saying that there are, and I can't see this.
That's what I was going to say. Let me click it for you, and I'll
Can you bring it up on this slide?
Yes, I will.
By saying that private prosecution is available to any person who wishes to seek a remedy through the criminal courts. You don't have to be a public prosecutor. This is an ancient common law right that is available across all of the common law countries, although it is more commonly used here in London than in other jurisdictions. The difficulty with being a private prosecutor is that although you have the ability to bring a private prosecution, you don't have any extra powers to obtain information or conduct a criminal investigation than the same rights that every one of us in the room have, and obviously excluding the gentleman from the NCA because he's got more powers than that. So there are a wealth of civil recovery tools that are available through the civil courts that we as private prosecutors are learning to make fairly regular use of. Among them is a Norwich Pharmacol order, which you've heard mentioned already. But I'm going to go out on a limb here and say I'm over Norwich Pharmacols. I'm done. It's yesterday's news. Thanks to Ramelos, they're no good to me anymore. I have a new toy, and my new toy is CPR 2511G. If you read that far into the civil procedure rules, you really deserve a judgment in your favor. 2511G, go back a step, 2511F. 2511F says that there is availability of a freezing order to a party in civil proceedings who needs to restrain assets in favor of an eventual judgment. Unlike Norwich Pharmacol, there is also an availability of 2511G, which says if you need to know something about an asset that is or may be the subject of a freezing order, then you can obtain an order from the court to tell you about that asset, including things like, I don't know, who owns it, which is very helpful for us. You might also be able to get information like, where are the mortgage payments made from? Which bank account is that? These are all the types of information that we might seek to obtain under a Norwich Pharmacol order. But Norwich Pharmacol order is, as they say, where I come from, which you all now know is West Virginia, a pain in the ass. And the reason it's a pain in the ass is it's not just as simple as, I have a good arguable case, and it's just inconvenient to you grant this order. There is also a problem with necessity. So the three conditions, the threshold conditions you have to get over in order to get a Norwich Pharmacol order is, I have a good arguable case that there is some wrongdoing. Also, there is a question of necessity. I am literally at my last ditch effort. There is no other way, per your case, that I can obtain this information and seek relief from the courts or whatever remedy redress I'm looking for than getting the court to grant me this Norwich Pharmacol order. And the courts take that necessity issue quite seriously, I think it's fair to say. You then have to show that the third-party respondent who holds the material is mixed up in the wrongdoing, innocently or otherwise mixed up in the wrongdoing. So when I hear about applications for 1782 from my colleagues back home, I'm sort of wistful because it just seems so straightforward. Well, 2511G almost fits that model. You just have to say, it's just inconvenient, and I think they have the material. And that takes a lot less time and is a lot less cumbersome of an effort. However, it's fair to say I haven't done one yet. So you might find from me next year that I'm a little bit less enthusiastic. So moving on to unexplained wealth hoarders, which are available only to public prosecutors. So when Ed asked me to speak about them and their usefulness to a private prosecutor, I said their usefulness is zero because I can't have one. So the only time unexplained wealth orders are going to cross my desk in my life as a private prosecutor are going to be if I'm defending one on the admittedly small side of my practice that is defense related. That being said, I'd like to be a little bit of a ray of sunshine here at the end of this long afternoon that has put, don't lie, a couple of you to sleep, and say that there's somebody yawning right when I said that. Goodness, Ian. Did you do that on purpose, or was it just on
Perfect
accident?
timing.
So I am going to be a little ray of sunshine and say that here in the UK, unlike in the US and unlike in Jersey, everything is smiley for those of us who are trying to trace assets. The courts cannot do enough for us. They are bending over backwards to help people that are seeking to trace assets. And most of that is because of a very lovely gentleman who hails from Kazakhstan, and his name is Mukhtar Abyazov. Friends of anyone in the room?
Not that far away, neighbor. He's a bit more up my, he was a bit more up mine.
Well, he's a very, very good man to us litigators because he stole $10 billion from his bank that he kind of owned, but maybe not. And he brought all that money to London, which meant that when the bank eventually came looking for it, they came to the London courts. And they came with $25 million worth of legal fees, worth of legal fees, which they gave to Hogan Level and said, could you please try everything in the asset tracing and fraud investigators book that has never been tried before? 10 years later, we have a raft of new capabilities. Up on the screen, you'll see a case called BTA and Krapanov. That was one of 13 actions brought by BTA through Hogan Level, who are like the happiest lawyers in the world these days. And BTA and Krapanov gave us a wonderful new remedy. And this new remedy is called unlawful means conspiracy for assisting to evade the effect of a freezing order. What does this mean? What it means is if a freezing order is in place and a third party, say, for example, a corporate service provider, opens up a company, shunts in some assets belonging to the defendant to the freezing order, thus allowing the respondent to the freezing order to evade the effect of it, then that third party can be liable for tortious relief against the person who obtained the freezing order. Did that make sense? I thought it was quite clear. Yeah. Basically, if you help someone evade the effect of a freezing order, then I can come after you. Now, there might not be very many BTA and Krapanov-like cases. Well, I mean, there will be if I have anything to do with it, but if you do have this threat behind you, as someone who is trying to seek information from or obtain assistance from a corporate services provider, it's always helpful to have a cause of action against that third party as well. Do you want me to say anything more about unlawful means conspiracy?
Why don't you hold it till after,
Yeah, maybe
after
after we'll
lunch?
pick it up, 'cause I think it's
I mean,
very
after
interesting.
coffee break, because we've got a short coffee break, and we've saved all the really, really interesting stuff for the second half of this. So this was just to whet your appetite, and we'll see you back here in 10 or 15 minutes with hot steaming coffee and ready to go.